With that, I will call the case, which is People of the State of Michigan versus Alexander Haupt. And this is a mini oral argument on the application, 15 minutes of argument per side. Mr. Friedman, as you know, we have 2 minutes of fire-free zone, and you may reserve time for rebuttal, but we just ask that you try and keep track of that yourself. So when you're ready, you may proceed.
Thank you, Your Honor, and good afternoon. Stuart Friedman, together with Suzanne Schulke, on behalf of the defendant. I would also note and welcome the MSU law students who were student attorneys for CDAM, who are also sitting in this courtroom. I would like to reserve 3 minutes for rebuttal argument, and before I step into the free fire zone, I do want to take a couple moments to turn around and speak about the timeline.
Excuse me, Mr. Friedman, I'm so sorry. I think the clock isn't running, so we just wanted to double check that. Thank you.
Thank you. Okay, go ahead.
Your Honors, starting in April of 2018, and to be clear, this is not a challenge to the waiver that happens in 2018. This is for background for what happens in 2019. My client was in the Clare County Circuit Court, and his first attorney, Scott Grable, moved to withdraw. He cited that the client wasn't being attentive, he wasn't responding to calls or getting back to him. The judge denied that motion to withdraw, but the story wasn't over. In June of 2018, Mr. Grable renews his motion to withdraw, this time citing my client's statement that Mr. Grable's outburst could cost him his law license. This was apparently Mr. Grable's line in the sand, because Mr. Grable stated that the defendant at this point had become communicative, he was otherwise polite, and wasn't being obstreperous. The trial judge allowed Mr. Grable to withdraw and set a new hearing date 60 days later in August for a check-in on whether or not the defendant had obtained counsel. It's important to note that there is nothing in the record here where Mr. Grable or Mr. Haupt indicated that he would be representing himself. This becomes important for what happens later in the case. In August, the defendant appears before the judge on a check-in. He tells him he does not have sufficient funds to hire counsel. The trial judge responds at this point, "Cost is not my concern," and he does not inform him of his right to counsel. Instead, he speaks to the defendant about how his being difficult may be the problem with him hiring counsel. The matter is then adjourned until October. Now, in October, my client still doesn't have counsel. And what happens at that point, October 23rd, dates are going to be important for a second, is that my client does have an outburst. He says, "I don't need no public defender, I can do better myself." That's a paraphrase, but it's close. What we know at this point is that 3 days later, counsel is appointed for the defendant. So there is a change of heart. I believe that on October 21st, 23rd, right after the hearing, the defendant actually fills out the forms. The Clare County file is sealed right now. I couldn't get that order, that document before today's hearing, but the court has the file and it can check it. Either way, on October 26th, 3 days later, counsel is appointed. That counsel is Scott Moore. Mr. Moore files a timely motion to remand the case for a preliminary examination, which was allowed for in the original waiver because they thought they had a deal, but my client wanted a trial. And that is a continuing theme here. He was offered, and I will concede, a terrific deal. It was probably a mistake for him not to take it, but it was his constitutional mistake to take. The case resumes in circuit court in March. And at that point, it progresses to June of 2019, where Mr. Moore moves to withdraw. My client concurs in this motion, unlike the Grable motion, where he really did not want Mr. Grable to withdraw. He was fully satisfied with him, except for that one disagreement. And the judge allows Mr. Moore to withdraw, but to remain on as not co-counsel, but standby counsel. At that point,
Mr. Friedman, can you, I think the
That's
timeline is obviously very important in this of what happened. I think we're familiar sort of with what the timeline is of that. I think the legal question that, is it your contention that once he waived his Sixth Amendment right to an attorney and then invoked it again, that he needed to have a full waiver again? Is that like a per se rule, or because of the time? I mean, is it a fact-specific analysis of when that happens? But is it once you've re-invoked or you've invoked the right to counsel, that any waiver then you sort of hit a reset and you have to affirmatively waive it?
I believe in this case the judge should have given him a full Ferretta-Anderson waiver, provided for and summarized in MCR 6.005, subsection D, which included advising him of the maximum, advising him of the dangers of disabilities, etc. The United States Supreme Court did not want this to be an easy process, but at minimum, he should have been given the summary warnings provided for in 6.005 sub
So
B.
is that any length of intervening time? I mean, if he had that full warning and waived his rights, and then 3 days later invoked the right, and 3 days later, so we're, I mean, here, I understand there was a passage of time of 8 months, there was some period of self-representation, and the question is, what is a critical stage of the proceedings on some of that? But is it a hard and fast rule that once you've invoked it, it requires a full waiver every time, or is it sort of fact-dependent on what time and what conduct has elapsed between those?
I understand, Your Honor. In my brief, I cite the cases from Iowa and Minnesota that talk about that, which I suggest offers the appropriate rule. It talks about change of circumstances, passage of time. In the Iowa case, the court said that 3 weeks was close enough, but that 8 weeks wasn't. Here we are at 8 months. 8 months, I haven't seen many cases that have gone that far out. And we do have a change of circumstances. I mean, first, my client really never appeared in court at a critical stage self-represented, and he didn't even appear in a stage where it could have been corrected or where there were serious motions. He backed down immediately. The warning worked. And I think that's one of the takeaways here. Now, whether the 6.005E warning is constitutionally required in every case, I don't believe so. I have seen a few where that wasn't, but it's in a rapid series, it's in a series of events. It's not a change in circumstances. It's different counsel, it's on the eve of trial. It is not something that just carries directly over. My client's original waiver, I don't believe was out of autonomy. I think my client was a little bit of an impetuous brat, to be honest, when he did that. I can do better than any public defender, but he backed down when reality set in. We have no reason to think that such a warning wouldn't have worked here. I would also note that beyond my case, if the judge had adhered to these practices, we would have saved the entire system of justice a great deal of time.
Counsel, could we just let's just assume I agree with you that the waiver wasn't valid, then we look at the critical proceedings. Mm-hmm. Can you help me figure out why that issue, at least as to the motion to suppress the evidence from the cell phone, was not remedied when his second lawyer did argue that at the time of the actual trial? I mean, was it just he didn't have enough time to prepare? It can never be remedied? How do we deal with that? The fact that he did actually get a chance to make that argument?
And he didn't do bad for one day's preparation, Your Honor. I will concede that. But one of the things with standby counsel and Mr. Moore's vision of it was that he did not view himself as an understudy. He viewed himself as a technical advisor. He stated that he wasn't prepared. He had one day to get prepared. Now, I could go into other factors, and I feel that I'm a little bit in a difficult position here. I've argued Hughes and Carson before this court. So what I might have argued if I were sitting in his shoes would probably be a little bit different than the way he approached it. But I will grant you that that is the most secured of the lot, and that would be my most difficult argument. But if we look at the other issues, where they struck my client's witness list, where they excused the complainant, where I would suggest that the complainant's mother, if you had an attorney issuing a subpoena, she would have been there, not making a day trip to Mexico to have cosmetic surgery, may have been different. If you go to the 2021 Court of Appeals decision in this case, when we speak about the other issues, they refer to them as case management issues. They refer to them as evidentiary issues, which go into the heartland of discretion. So we can't say that with the guiding hand of counsel, a different result would have occurred. Now, while I'm on that 2021 argument, I'd like to point out what I think is a technical error in the Court of Appeals opinion that I just caught prepping for here. I argued to the Court of Appeals that the Army regulation, cited in my brief here, same regulation, same argument, allowed the Department of Defense, specifically the Army, to accommodate a request for AM to appear either in person or at least by Zoom. And they said that I argued that the commanding officer could have been subpoenaed to the court to testify. I made no such claim. I said something I would say is analogous to the procedures that we use on former res justi witnesses, that methods can be used on request to accommodate them. Even if I couldn't have had the prosecution's assistance, certainly a defendant could have said, we have 5 weeks before, an attorney, that we have 5 weeks before trial, Judge, give me a certification to the Army that she's needed, and I will reach out, I will try to handle her. This is a discretionary issue, and I don't know what the trial judge would have done if it had gone beyond the day of the trial, but we have no indication that he wouldn't have granted that. Further, as I've noted elsewhere...
So, Mr. Friedman, can you tie in, so there are a number of different hearings that occur pre-trial, sort of tie those to, you know, let's say the Bell versus Cone definition of a critical stage, sort of tie it into why does this, and how do we draw the lines on when it's a stage, formal and informal, in court or out of court, where counsel might derogate from the accused's rights to a fair trial. So how do we draw those lines at those pre-trial hearings?
Well, I believe that Judge Karen Moore Nelson, in her separate opinion, a dissent in the Sixth Circuit, did a nice job. She stated a couple of things. First of all, that we should not let critical stages be a backdoor harmless error test. Okay? The question isn't whether we look at a poor record argued by a pro se litigant and say, do I think that if things were different, counsel could have moved the needle? Now, I don't have a specific answer between what's in court and out of court, because when you're prepping for trial, it really is the same. It's two sides of the same coin. You are looking to get, use my Army example, if I had the certification, I would still have had to go forward with the stages to implement it, or it wouldn't have occurred. When you look at the issue with respect to whether an issue could have made a difference or not, it's really easy when it's a pure question of law and a pro se litigant misses it. But when you've got an issue that is a discretionary issue, where the record has not been developed with that in mind, where it has been developed by a gentleman with an 11th grade education and is 21 or 22 by the time of the trial, it's really easy to play Monday morning quarterback on that. One of the things, if the
So in this case, was it your client's choice to have a motion to suppress hearing without an evidentiary hearing, or was that a choice that was already made by the attorney, for example? So that's a hearing where it might have been contested with evidence.
My client delivered that motion to the judge. My client signed off on that motion to the judge. Portions of that motion were written by Scott Moore. He gave him his work product, but I have no idea which portions, Your Honor. I'd like to talk a little bit about the issue of forfeiture by conduct, if the court is through with the issue of critical stages. Because I really think that this case turns more on a question of forfeiture by conduct through the defendant's actions than whether or not he has done it as a matter of choice, as a matter of autonomy. And I would note, before I did move on, though, that Ferretta talked about an unequivocal waiver. And even if my client went forward because he really didn't like all the options, I'm not sure how unequivocal it was.
Counsel, I see that your time is up, but I do have a question about forfeiture. Are you aware of any single case in our state that has recognized forfeiture in the context of the right to counsel at trial?
Well, there is the Comrade case, Your Honor. I think my case is distinguishable from it, but it is clearly out there. And the Gross case that I cited, which is unpublished, also reference to that. I know I'm out of time right now, so I will be happy to continue on rebuttal if the court has any questions.
Okay. Thank you.
Good morning, Your Honors. May it please the Court, Autumn Wilma on behalf of the plaintiff appellee, the people of the state of Michigan. This court should deny this application for leave to appeal for two reasons. First, the defendant waived his right to an attorney. This court indicated in Atkins that evidence of a defendant's intentional manipulation or delay of the court proceedings as a tactical decision may favor a judicial finding of a knowing and intelligent waiver. In this case, not only did the defendant expressly waive his right to an attorney in October 2018, but he intentionally manipulated and delayed this case as much as possible. Appointed counsel may have said it best. The entire criminal justice system could be held up in a program based on these shenanigans. Thus, the defendant's manipulative actions were exceptionally egregious under Camerad to warrant a waiver by conduct. Second, the defendant was not completely deprived of counsel at any critical stage that pervaded the entire proceeding. None of the stages at which defendant was without counsel have been recognized by this court or the U.S. Supreme Court as critical stages, nor should they, given that defendant did not irretrievably sacrifice or lose any rights or defenses then and there during those stages. These are not stages where the bell cannot be unrung, like that in United States v. Wade or Hamilton v. Alabama, where the results might well settle the accused's fate and reduce the trial itself to a mere formality. Ultimately, this defendant intentionally manipulated and delayed the proceedings, and he should not be awarded for his efforts. I would like to go back to your question, Justice Hood, and explain Camerad more. Particularly, Camerad uses the word forfeiture, and this court in King specifically said that an uncounseled defendant cannot forfeit their right to counsel. The forfeiture used in Camerad is a different concept of forfeiture. It's not the failure to assert his right, it's that his actions outright relinquish that right. And when I reference this as a waiver by conduct, that forfeiture is what I'm talking about. It's that relinquishment of his rights based on his conduct. Now, I understand in Camerad the Court of Appeals differentiated between forfeiture and waiver by conduct, but because these terms have been used so interchangeably, I'm putting this just as a waiver by conduct, just in general. He relinquished his right through his conduct.
Counsel, I was wondering if you could expound more on sort of defendant's intention to delay the trial. I understand he disagreed with his lawyer. I believe his lawyer had a good plea deal and he didn't take it. That's a pretty common scenario in criminal law. I mean, is that enough to say it's the same as Camerad, where the you know, obviously the facts in Cameron were egregious. You know, you had someone who I think was, I don't know, refusing to wear clothes and using a wheelchair as a prop and doing lots of things. Does this case really rise to that level?
It would depend on your interpretation of egregious and the defendant's actions. It's really easy to outright refuse to do anything and just sit there and refuse. This particular defendant, however, used what the court rules and the constitutional rights to him to manipulate these proceedings. If you look at the Court of Appeals' original decision, they discussed how he waived his right to a prelim in order to entertain this really good deal given by the prosecutor for Haida on this case and 2 others. But then when it came down to it, he didn't want to accept the deal. He wanted to go back for a remand. He didn't want to go to trial. He didn't want to, he wanted to make sure that he went back. And obviously there was a disagreement, and Mr. Grable at that time ended his representation. But then if you look at what the court says on the day that appointed counsel is allowed to withdraw, the court specifically notes that this court has been delayed solely by the defendant's actions. It is completely because of his actions that this is delayed. And even if you look at appointed counsel after he is reappointed and admits that he may not be prepared on one day, specifically he says, "He's not hearing me, Your Honor. He seems to think that somehow I have this magic ability to force the court to adjourn this because we are unprepared based almost completely on the defendant's own actions." So again, the defendant is not wanting this to go to trial. He's wanting to delay it more. He's asking for counsel so that it can be delayed. Now, I understand that appellate counsel is arguing that when he initially said that he could do better, or the client said he could do better than appointed counsel, and then 3 days later had second thoughts, that that's one interpretation. Another interpretation is that the trial court specifically said, "I'm not remanding this case." If you had an attorney, then they would have known that they could have done this. If you had read the court rules, you would have known could have done this. You didn't. And so I'm not remanding it. And then 3 days later, he decided to ask for counsel because the court would not remand. Not because he needed counsel or didn't want to represent himself. He thought it was a way to get to a remand to further delay trial. Is an interpretation.
So where do you draw the line on sort of what would have been reasonable by a defendant versus the defendant here? Because defendants in the criminal defense context, they disagree with their lawyers a lot. I think any criminal defense lawyer can tell you that. They're trying to convince their client to take the plea, they're upset, maybe they're confused, maybe reality hasn't set in, who knows. Very common that they're upset at their lawyer, and very common to switch lawyers, very common. So it can't be that every time there's a motion by a lawyer to withdraw, and there's a time lag and maybe a new lawyer coming in, and then there's now a dispute with the second lawyer. Is that it? If you get 2 shots, and then after that it's unreasonable?
It's really hard to give a straight answer, Your Honor, because I don't know, and I don't think the case law is consistent on it either. This court, I could not find a case that was completely like this case. Even in other courts, in other jurisdictions, there is not a case that is just like this case. There are a lot of other ones, and they talk a lot about manipulative behavior or delaying the proceedings. And that ultimately is what it comes down to, is if the defendant's actions are such that they are manipulating the court, they are delaying this process, that justice cannot be done. If at a point where, and I don't know what that point is, if it's just the trial court saying enough is enough and this is why, or if there has to be a bright line rule, I don't know, because each defendant's different. In United States v. Green, there was a case where the defendant hired counsel, fired counsel, hired counsel, fired counsel, was appointed third counsel, and then fired him. And the court said, "I'm not giving you fourth time. I'm done. You can represent yourself or you can hire again." And that was deemed sufficient. It didn't involve any delay specifically in hiring at a certain time or asking for adjournments so much as it was, you've gone through counsel enough that you cannot use this right as a way to essentially make an appellate parachute. And I don't know that there is a bright line rule, unfortunately, and nor do we have a case.
Isn't that what we struggle with, though, right? Because it can't be dependent on the sort of patience of a particular judge, or else you're going to have wildly disparate reasons. I mean, there are cases that show multiple, and you just mentioned a fourth, you don't get your fourth. So maybe here, you know, he didn't get a third. I mean, like, that's what we're tasked with, right, of where to draw that line. And I understand for purposes of this case, you would like us to draw the line at where the facts of this case dictate. But we are looking not at just this case, but what that rule should be going forward for every other trial judge who is trying to navigate these situations, because as Justice Welch says, it's very common.
I don't disagree, and I think that's where the totality of the circumstances and what the trial court in this case looked at. It wasn't just that, how he was with appointing counsel. The court looked back at the case altogether and how he acted with retained counsel as well, in order to determine that this wasn't just this attorney that we were having issues with. This wasn't just that you are bouncing from attorney to attorney, that it's more than that. And so I don't know that totality of the circumstances is necessarily the right way to say it, but I think that's the best way to go about it. Because that's,
I'm sorry, could you address 6.005E, the advice at subsequent proceedings? I mean, you wouldn't dispute that the trial judge didn't comply with that portion of the court rule.
I would not dispute that the court did not comply with that portion of the court rule after it determined that Mr. Haupt had waived his right to an attorney. I think that if you look at that hearing where the counsel is allowed to withdraw, the subsection E specifically says that at the beginning of a hearing, when a defendant is without counsel, these warnings should again be given. But at the beginning of that hearing, he had counsel. And then that's when counsel was going to, they explained what the difference was in opinion and why there was this disagreement and why the relationship was strained. And the court found, based on that argument and everything else, that you have waived it. So I think what the court says at that time is a waiver, is finding of that waiver, not necessarily in conjunction with the subsection E.
But doesn't E require that advice at each subsequent proceeding?
So at any hearing after that in which he is, I would concede that he did not address those factors.
And so your argument of why that shouldn't be reversible error is what?
According to this court in People v. Lane, the trial court's not abiding by 6 subsection E is to be treated as just another trial court error, which would then be an analysis under Karen's for plain error. And I don't think he gets there with plain error because he did have a fair trial, which essentially is what this court said in King about Lewis, is that harmless error beyond a reasonable doubt applied because in Lewis he still had a fair trial. And in this case, he still did. So I think that that's why it would still not be a reversible error at this time. I would just note, going back to some of your questions to counsel, there is no case in this court that indicates that a revocation of your waiver of a right to counsel requires that subsection D be abided by again, or Anderson. Lane actually does say that this is a subsequent one. We are looking at subsection E and subsection E only. At least there's that case. It obviously is different in that that was a case where he didn't revoke his right. He revoked it during trial, not like in this case where he revoked it prior to trial. But there is not a case that says you have to go back to those subsection D factors.
Can you envision any circumstances in which you would think, or you would concede that waiver would need to be given again? If it was, the waiver was given, it was re-invoked, say I mean, could there ever be a significant enough time lapse or a change of circumstances that waiver, the objectives served by obtaining that knowing waiver really are, at play again, even though it had been revoked before? I mean, I understand, that you're saying it didn't happen in this case, but is it just a bright line? Once it's given once, you're good?
I'm not going to say there isn't, because even under subsection E, if the court doesn't think that the defendant is of that mentality to continue representing himself, that he understands that the court then appoints counsel. So I'm not going to say there isn't. However, the point of the initial waiver is that the defendant go in with his eyes wide open, that he understands the risks, he understands what the consequences are of self-representation. And so the court cannot grant that waiver if it doesn't find that it was knowing, involuntary, and intelligently made, or if it wasn't an unequivocal request. And so there's those factors that in an initial waiver aren't the same as in a second one, because now he can't say that his eyes are closed, that he doesn't know what the risks are. But I'm not going to say there isn't a second set of circumstances. Perhaps there's a competency issue that might have an issue later. I'm not going to say there isn't. I'm just that the original initial waiver is meant to a defendant to have his eyes wide open, that he knowingly, voluntarily, intelligently makes that waiver. It's not the same set of circumstances as subsection E. And that's why I don't, in this case, say it should go back to subsection D. It should be viewed as a trial court error under subsection E.
Counsel, could I have you briefly address the critical stage question? So imagine there's a motion to suppress hearing on a very simple possession case. And so really the whole case is the motion to suppress. There's an evidentiary hearing at the motion to suppress, and it's denied, and so there's a trial, but the trial is, here's the evidence, right? Would denial of counsel, would that be a critical stage in that instance? And then how do we distinguish that case from this one?
I think the important thing to look at, especially with not being a critical stage, is actually United States v. Wade, where the United States Supreme Court looked at Hamilton, Alabama, and how an arraignment was always going to be a critical stage because, especially in Alabama, you could lose a right by not asserting it at that time, then and there. And the same was said in Wade because of it being a pretrial identification. That harm involved with the identification then and there is the problem, and then that can have an effect on the trial. Such is not the case necessarily with the motion to suppress, because especially in this case, counsel did have the opportunity to make a subsequent motion to suppress, but counsel also had the ability to cross-examine those witnesses to, I apologize if I'm out of time, if I may continue.
No, go ahead.
But he had the time to cross-examine those witnesses, to challenge the evidence, and to show that I believe the Court of Appeals kind of alluded to it too, is that a motion to suppress isn't necessarily a challenge to the evidence. You're asking for a penalty on how that evidence was gotten. So he's not, it's not a critical in that he's going to lose a defense. Also at the same time, he was not uncounseled. The people mentioned in a footnote to their response to his motion that it was verbatim the motion that they got from Grable early on, and that the defendant only put his name on it. And and at the same time, not only did he then have counsel who gave him the motion, which he then read, but he had counsel later to argue that as well.
Thank you.
Counsel, I know your time's up. I have one more question. Let's just go ahead and turn to the other proceeding, or the question of the complainant's presence. So I understand there was the preliminary exam testimony, and so I understand your argument. How do you respond to defendant's argument that obviously he had a right to have her present at the trial, and that she could have been there? A lawyer would have understood those rules with the Army and her ability to be at the trial.
My understanding of the defendant's argument during that hearing was what the Court of Appeals found, that he could have subpoenaed the commanding officer. That came from the defendant's argument, not necessarily from appellate counsel. So a defendant alleged a way in which she could have been there. But at the end of that hearing, the court did not excuse her absence. The court said, if you can get her here, she will testify. We're only using this transcript if she does not appear. And she did not appear.
Thank you.
Thank you, counsel.
Thank you, Your Honors.
Mr. Friedman, you had used up all of your time, so you don't have any time for rebuttal. So the case will be submitted.